Good morning. Is it still morning? Is it afternoon? I guess it's afternoon now. I'm trying to catch up. Certified organic line of products based out of the Orlando, Florida area. I am also CEO and owner and founder of a company called Promessa LLC. Promessa stands for promise, and I specialize in compliance and regulation, everything from your content, your reviews, your labels, etc. I have been actively involved in several of the corrective action plans for many brands that have been cited by the Federal Drug Administration, the FDA, and the USDA, and instrumental in cleaning up a lot of those issues. I am Ethics and Compliance Chair for the World CBD Awards. We're coming into our third year, although we skipped one. And I am authored, public speaker, etc. I have been in this industry for going on 7 years. Anybody that knows anything about this industry, it was coined yesterday. Those are dog years. It feels like we've been doing this for 100 years now. This has been an interesting industry in the way that it has developed over those years, having started with some backroom bodegas and bathtubs, mixing some things up in home kitchens, to where we stand today in compliance, regulation, state, federal, and now international. Today, I am joined by an incredible panel of professionals in the industry, and we will be discussing legal opinion on what you can and cannot say with regard to your product, both in a room like this and in digital content, marketing strategies, collateral, etc. The name of the game here for the CBD Expo is really to keep you out of trouble. When the FDA sends out that initial letter, just to give you a little bit of insight, the bill starts somewhere around $3 to $6 million. And eventually you hope to settle out for a little less than $100,000. So we hope to try to avoid those situations by bringing you an education that will enable you and empower you to do it right. So without further ado, I'm going to allow each panelist to take a moment, introduce themselves, tell you where they're from, how they stepped into this industry, what the name of their operative or their operation company is, and then we will slide into some questions. So let's start with Blair.
Hi there, good afternoon. My name is Blair Curlis. I'm a pharmacist in Georgia. I've been involved in helping other companies ensure that their labels are somewhat compliant as best as possible. I provide no legal services. So beyond what I help them, I tell them to go find a lawyer to ensure everything's compliant. And I've been involved in finding substances that are on the market that are adulterated and have them sent out to labs. And a couple of them have gotten up to the DEA and the FDA where warning letters are sent out. So I'm really against adulterated and I guess products that are out there. You can need to label everything and ensure that you're not putting something in there that will produce harm to the consumer.
Hi, I'm Liz Geiselman, and I am the CEO of Rocky Mountain Reagents, and 710 Spirits is our extraction line of products. We have over 2,000 chemicals, so it would be hard for y'all to find what you need in my website, so we made it 710 Spirits extraction products. I have been in chemical sales for 22 years and in this industry for 12. We are an FDA-regulated facility when it comes to not only consumer-facing products, but also industrial products. The labeling regulations are pretty robust. I also serve on the, I'm the chairman, I'm on the board of directors for the National Cannabis Industry Association, as well as serving on their committee for manufacturing safety and product safety. And I've also served on the CHAMP committee initiative in Colorado, which is the Colorado Hemp Advancement Management Plan. In that it was a 2-year, 500 stakeholder process where the state of Colorado basically wrote all the regulations that the state was going to do around hemp, with in mind, keeping in mind what USDA, FDA, all of those governing bodies are probably going to do in this arena once things go more federal. So that's kind of my background, and I've been involved in the political spectrum for about 15 years when it comes to cannabis policy.
Good afternoon. My name is Roni Schmeltz, and I am an attorney with a firm called Tucker Ellis. I am based in California, but I'm licensed also in New York. I spent the first good number of years, I'm going to refrain from saying how many, working for a large international law firm where all I did was primarily class action defense and representing companies in litigation. My practice evolved about 10 years ago where the focus really became on consumer product companies. And I would say now my practice is about 50-50. 50% continuing with litigation, primarily defending companies in consumer class actions as well as in some consumer commercial disputes, as well as 50% now on litigation avoidance strategies. We go in and we work with companies that allow them to basically not have to worry about compliance, legal issues, but focus instead on growing the brand. So we do everything from, we look at every piece of consumer-facing literature that you'll have, starting with your packaging, to your website, to your social media, to make sure that you're not overstepping the bounds. And when you thought you were marketing a consumer cosmetic product, only to find that because of some claims you've made, you're actually now selling a drug and having the FDA knocking at your door. We also help to ensure that you're not going to get a letter or an action from the Federal Trade Commission, that you'll be able to substantiate your claims. So we look with companies, we look at their portfolio, their dossier of claim substantiation, and make sure that they really can support and tie the claims that they're making to sound evidence based on the science. And we then help with everything from looking at your website to make sure your terms are compliant, you're not violating the privacy rules, which are pretty rampant now all over the country, help internationally with IP portfolios, everything you can think of that an outside general counsel would be able to help you in order to avoid litigation. And while it's true that if you get a federal FDA warning letter, my experience, we've been pretty lucky on getting those resolved without actually having to pay, depending on what the nature of it is, but it can be very expensive. So the ounce of prevention really works here, and we're better off if you get in early, make sure that you're compliant early on, and then you don't really have to answer to the federal government because they're not looking after you. There's a lot going on in the industry. They're not going after a lot of players for reasons that are obvious. I think there's a lot much going on at the government level that they don't have time to go after all these companies. But if you do get that call, you want to make sure that you can support yourself, defend yourself, and position yourself so that you really don't get hit with the worst of all, which would be a consumer class action, because those are the ones that really cause you to have to pay out some serious money in order to get those resolved. So I'm happy to join you today and look forward to discussion, and hopefully it's robust with questions from all of you guys as well.
Perfect. How many people in the room are starting or thinking about starting brands? Okay. And how many people in the room are looking towards other avenues or revenue streams within the industry that include extraction, grow, et cetera? Okay. I'm just looking for relevance here so that we can tie it all together and make sure that this is informative. So Blair, at the introduction, you said that you were big on identifying products that have been adulterated and calling those out.
Yeah.
Can you go into detail why that's so important?
So being a pharmacist, I like to know what I'm taking and putting into my body. I go around with the vape shops, head shops around the areas, talk to the owners. I'll see their customers that are in the shops. And I can see how weird they act. For instance, Fubinaca, 5F Fubinaca is what I found in this vape additive, and it's intoxicating, really intoxicating, nice and quick. And it'll make you really whacked out. I've even seen like high school age kids, really young kids and stuff. They'll come in and they'll hit these little vape cartridges and they'll turn white, like they're about to pass out. Almost have to call an EMS. Make sure that they're okay. I don't want that to happen. I don't want that to happen to anybody. So as a pharmacist, I like to have quality control and know what's in these products, so it doesn't cause you harm or someone else. because someone's intoxicated and now you're in a wreck. This is no good. So that's why I go around, make sure that everything's okay. It's just one of my ways of ensuring, I guess, the public they're going to have good products, and it's good repertoire with Georgia Drug and Narcotics Agency.
As a pharmacist, coming from that position, counteractive or counterintuitive results from taking the products in tandem with taking pharmaceuticals, can there be, everybody says it's 1,000% safe. You can't overdo it. You can't hurt yourself. In your opinion, is that true or false?
I would definitely say that it's very counterintuitive. So we don't know how they're reacting in the body. There's plenty of evidence that are coming out with different type of enzymes. The same liver enzymes that are breaking down and metabolizing your drugs are also found in the brain. So if you have the wrong type of genetics in there and such, that's why you're seeing patients or users out there that use these illicit drugs, these cannabinoids. And some of them are okay, but then some patients go whacked out, totally crazy. You'll hear these stories in the newspapers. Those are the ones that we're afraid of.
Very good. Thank you.
Mm-hmm.
From the side of legal, the value or the benefit of getting out ahead and being compliant in all collateral, consumer front-facing, what are the advantages to that?
Well, it's a question really of what your risk tolerance is and how much money you have. Oftentimes, they're conversely related. Oftentimes, people are really taking a lot of risk and don't have a lot of money when they're attacked. I often get asked, well, why can't I say it? Look at so-and-so brand that is saying that. If they can say it, why can't I say it? And the answer is that the brand that you're looking at usually typically is a well-known brand that is well-funded and has built in these sort of daring, perhaps actually obviously illegal claims, because that's part of their marketing budget. So even if they get attacked, they just figure, now I've been able to get this out to the public, my message has come across, so even if I get hit and have to pay something, I've still achieved what I was hoping to achieve. And with most brands that are starting out, you really can't afford to do that. And I'll give you as an example the way this really plays out in the real world. If you get a letter, and typically in California, you will see a consumer demand letter before you will see a lawsuit. And the reason for that is because by giving 30-day notice, they're able to then sue for damages, monetary relief, as opposed to injunctive relief, which is basically just telling you to stop doing something, which is what the government wants, right? When the FDA sends you a letter and it's recounting all of these claims that you're making, the FDA isn't there to negotiate with you. The FDA is telling you these claims that you're making are drug claims, and it's an illegal drug, so stop selling it like that. Either go get a new drug application in, and we'll bless the claims eventually, or stop making the claims because they're illegal drugs. That's what the FDA wants. What the consumer wants is money. And so what they'll do is they'll send out, and incidentally, so many companies are so phenomenally talented on conveying to the consumer and the world this phenomenal brand that looks like it's a serious, well-running machine and is making a lot of money, when in fact, it's just you being really creative and conveying a really well-established, long-established company. Consumers that are out there have no idea where you fall within that spectrum, from the startup to the well-established to bringing money in the black or in the red. They have no idea. So they'll send you a demand letter, and the demand letter will basically say, I went out and bought a hemp product, and you said there were X percentage milligrams of so-and-so in here. I had it tested by a lab, and the lab came back, and the lab said it's not at that level. That's a lot of what we're seeing. We're also seeing consumer brands that are out there with CBD in their skincare products, as an example, claiming that the product will perform in a certain way, reduce lines, fine lines and wrinkles, help stimulate collagen. Those are all drug claims. But what they're focused on is it's false advertising. You said this product would do something and it didn't. All right, so now what happens when you get the letter? The consumer wants money, pure and simple. And so what they're going to ask you is, because the statute of limitations is 4 years, for example, in California, they will come to you and they will want to know, for the last 4 years in the state of California, How many units did you sell? How much was the retail value of the product that I'm challenging for that 4-year period? And that's what they're going to want. They're going to want a piece of that based on your sales in the state of California. Aggressive lawyers will not stop there. They will either have a California lawyer and a New York lawyer or a Florida lawyer, a representative, and so they'll sue you for multiple states, or they'll sue you nationwide. So that's what's at risk here. Your exposure for last 4-year period in terms of the amount of sales that you've brought in. And different companies, again, have different risk tolerances. That could make or break companies, or with other companies, they're willing to take that risk. And so it's really a matter for each individual company that we counsel. My approach is not to tell any company you can or cannot do something. It's your business. You're going to make those ultimate decisions. I'm here as a counselor to counsel you on, here are the wide spectrum of risks that you're basically exposing yourself to. And it's really up to you. We'll work with you. If you want zero risk, we'll work with you to put in a program that should absolutely reduce the risk. Many people don't like that because it's hard to differentiate your product. You're not really saying anything. So we inch it up, and we talk to you about putting together a program and communication to consumers that will really make you feel more comfortable. And we also monitor all of the claims and all the cases that are going on out there, not only what the FDA or the FTC are doing, but we know what consumer lawyers are interested in. We know what they're going after. And so we can say that, this isn't the type of claim that we've seen consumer lawyers come after, or this is absolutely within their bullseye. So you've got a heightened risk right now. Just think about what happened with the industry in food and in cosmetics and everything with the use of the term natural. It's not defined. The government has left a vacuum, and unfortunately, consumer lawyers abhor a vacuum. So they've stepped in to sue every company using natural in order to impose on those companies and in the industry the plaintiff consumer lawyer definition of natural, which is extreme. So there's a lot that goes into the calculus, and that's what we bring, is the expertise allowing you to understand all of these different moving parts so that you, again, can focus on doing business while reducing your exposure to either regulatory action by the government or by a consumer lawyer.
Thank you. Liz?
And I'd just like to not only add to that, especially with those people that are wanting to start new brands, it is absolutely vital to have someone like this that's going to look at your labeling. It's vital to also employ a regulatory consultant to really make sure that you're hitting all the notes with all the other regulatory agencies like fire, GMP, just making sure you're hitting all those notes. But then also it's imperative that these things are reviewed annually. We've seen things in California specifically. California loves to do things with their laws on this. And we've seen some legislation that came through that changed some of the labeling protocols, that it is not their burden to tell you, it is your burden to know. And so making sure that you have someone that's looking at these annually as a review, because it may come down from a state, it may come down from a federal, and kind of watching that is difficult when you're just trying to be an entrepreneur and running your business. So I would say it's absolutely vital to have someone in this capacity, but also annual reviews are necessary. I bring this up because there's another company that I work with, and it isn't in this space, it's in the chemical space. It's a consumer-facing brand. In 2017, California made a ruling about how they could label cleaning products. My client did not know this. It was 2017. He has sold multiple units throughout that time. The state of California is trying to fine him $10 million. So it is absolutely vital that you keep up on this, or have someone at your disposal that you can keep up on these things.
And in this area in particular, you should know if anybody is selling product into the state of California, which is either the 6th or 7th largest economy, so I imagine any brand is going to, we've got, like you were saying, horrible laws. We've got Prop 65, which I'm sure many of you have heard about. We've got carb regulations. Prop 65 right now is getting ready to add hemp to that in terms of the exhale, the vapors and the like. So yeah, it's absolutely critical. And I mean, the good news is, for the most part, if you hit the requirements in California, you're typically pretty good across the country. There are exceptions for sure. This industry in particular is a quagmire because the federal government has thus far failed to come forward. And the reasons that they haven't, by the way, The reason the FDA is taking so long is for the very reasons that you were mentioning, which is there is so much that is unknown. And the FDA is grappling with, okay, maybe we can say it's okay for dietary supplement. Congress is at their heels wanting to have an exception so that you can have CBD in dietary supplements, even though the federal government, the FDA, has basically said, we don't know enough about it. We don't know if you're going to take a dietary supplement in the morning and then you're going to put on your facial cream that's got CBD in it. And then when you get home at night, after a glass of wine, you're going to take a gummy to help you go to sleep. The FDA, I think rightfully so, is basically saying, whoa, slow down. We don't know what the cumulative effects of all of this is. And we also don't know what delivery system has what impact. And so it's really quite critical that you are out there making sure that you're complying with the laws. And because the federal government hasn't come in and stepped in, the laws across the states are as dynamic and as diverse as you can possibly imagine, particularly with labeling. You need a QA code?
Okay.
Do you have to have all these things? And so it's really quite important to make sure that you have somebody, because you don't want to be doing this. Frankly, I don't want to be doing this. I have a colleague who does this, who is on top of every single law in every state and local authorities in order to be able to do that. But it is absolutely critical, because otherwise you're going to get your ass bitten when you get a regulatory letter, and that's the last thing you want.
So let's bring it back to the content or the purpose of this particular forum, what you can and cannot say. Liz, you've been doing this alongside of me for quite a while.
Yeah, I know. We should go on a road together.
We should do a road show. Can you give examples of what you can and cannot say specifically?
Well, there's not a whole lot you can say. I mean, we've seen, I think one of the most vital things that you can do, especially as a new company, is go to the Federal Trade Commission's website and look at what letters are being dispersed out to those companies, because it is very clear. Some companies have gotten minor fines for things saying scientifically proven. There's one that got an $85,000 fine because they were making claims against that it was curative for Parkinson's. So you will see amazing claims out there that can cause your company, quite frankly. The other thing that you really want to be able to watch also, because if it's a federal regulator, they're not walking around to all these businesses. They're going to your website. They're carefully scrutinizing your language on your website, because then they can look at 40 companies a day if they need to, rather than coming out to your facility and doing this. They're going to the shelves of Sprouts or gas stations. They're looking at your labels there. And something that came up earlier that I hadn't considered, you also want to look at what social influencers are doing, because you have to make sure that social influencers aren't making claims on your behalf, because that's still part of your brand. So those are kind of my tricks of the trade, but I would definitely get on the Federal Trade Commission, because especially in this year, they've come out 3 times with letters to CBD companies specifically.
Blair?
Check out the FDA website, because the FDA website will have a list of warning letters that are sent to companies. Those usually do not come with a monetary penalty, but they do call out what you're saying on your website and otherwise to look at that. The FTC has already told us they're no longer sending out just letters. At this point, they're kind of fed up, and now they're taking action. So you're seeing now, you can get information about what these companies are saying. But just to give it to you in a very simple, you can take this out of here, you can't say anything about the efficacy or what the CBD in your product does, period. Because you don't know. You didn't do the testing on it. So you can mention that the product has CBD in it, but if you say anything about that product delivering or performing in a certain way, i.e., if you mention a disease, if you mention a medical condition and imply, because it's not just what you say, it's what you are implying to the consumer. If you are implying that the product that you are selling to them that contains CBD will have an impact on the structure or function of the body, or will address a medical condition as benign as seemingly acne or eczema, that is a drug claim, and you will get a warning letter. And the worse the claim, the more likely you're to get the warning letter. And so the warning letters that have come out, it's just these, of course you're going to get this warning letter. You're curing cancer. You're curing COVID. I mean, of course you're going to get a warning letter. And so that entity doesn't care, obviously, because it is so clear. And so they're just figuring they'll sell as much as they possibly can so that when they get an $85,000 hit, they've sold millions. So 85 is nothing. But the bottom line from the legal standpoint is you can't be making claims about your products that they will basically perform in any manner unless you can substantiate it. So if you're going to say it reduces fine lines and wrinkles, or it's going to make me feel mellow and yellow and jello, you better have support for that. That's for sure. That's the ground level absolute. But if you're going to go beyond that and make a claim that is a drug or a body function claim, that is a drug claim, and look for a warning letter from the FDA. And the point about consumer influencers couldn't be better stated. You are responsible for every piece of real estate that you own that you're using to convey to the consumer. Now, you don't own Amazon, but you give Amazon a blurb if you were to be able to sell on Amazon. You give them a blurb to describe your product. So you own that. Good luck, though, getting Amazon to make a change for you. So Amazon's a little bit more complicated. But your Facebook, your Instagram, if you're going to say things on there, they have to be as clean as if you were putting it on your packaging or on your website. And if you have an influencer that's working for you, free advice, go out and get a contract with them to make sure that you delineate exactly what they can and cannot say, and police them. It's not enough to tell them they can't say it. You have an obligation to make sure they're not saying it. And this extends to consumer reviews that are on your website. If you have a consumer that says in their review, this is the greatest thing. I used to have migraine headaches and they're gone. I had eczema. This cream is amazing. Those are drug claims. And because it's your website and you own that real estate, it's incumbent upon you to scrub the website of those drug claims. Because the FDA, when they're sending out their warning letters, they're not just looking at what you're saying on the website. They're looking at what consumers are saying about your product. And if they're making drug claims, it's as good as if you made it yourself if you leave it on your website.
And I just want to add to that. We had in our earlier panel discussion, there was a question about, well, Epidiolex is CBD and they've made claims, right? That doesn't hold true just because you have CBD in your product. Unless you go and go through the process of your product becoming a pharmaceutical product through the FDA process, through licensing and regulatory, the regulatory process of getting your product as a pharmaceutical, you can't make that same claim just because CBD is being used in a drug that is approved. That's going to be a different thing. So you can't make claims even though Epidiolex is making claims about CBD.
Blair.
I just wanted to bring that.
Thank you.
Yes.
From your position as a pharmacist, when a consumer comes in, picks up a package and says, this is supposed to do blah, 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 how does that hurt the consumer? The false expectation of a promise of efficacy is the question.
Yeah, that can go many different ways, just like as a pharmacist, when I dispense the medications to my patients. Everything on there, everything that I dispense is not a cure. It is a treatment. Nothing that we have, I don't think, is a cure. So we have treatments that are approved by the FDA, whereas this stuff is not FDA approved or anything like that. So you can say you can use this to see how it can benefit you for this ailment. That's about as much as you can kind of do. Just take 2 of these, call me in the morning, kind of claim, but it hurts the consumer in a way that you can't give a specific on, say, you got Crohn's disease. So you take my liquid formulation, it gets right into the system. Oh yeah, this is going to treat your stuff all the way. I would not say that.
Thank you.
I would say this is your ailment. See how this goes. Let me know how I can help you, and we can go from there.
Technically, this industry is only 52 months old, really. And we still continue to forge. We're creating history. We have to adapt and pivot and adapt and pivot. So as we move along, we learn new things all the time. Keeping that in mind is imperative as you move forward with your brand, your product. At this point in time, I'd like to take questions because we're running out of time. And I want to make sure that we address any questions that you might have.
Hi, thank you guys. My name's Casey. I was curious if you're seeing the FTC and FDA coming after products in the medical market in the same manner. Is that I know medical's different, it's state by state. I just was kind of curious if all the things you've discussed today would apply. Are they a little bit more lenient because we're in a state where it's, we're talking about medical marijuana? Can you talk a little bit about the difference or similarities there?
Well, I want to make sure I understand the question. Are we talking about how are they dealing with medical marijuana claims or medicine like Epidiolex? And I'm a little confused.
I just didn't know if they were attacking brands in the same with the same are they more focused on CBD because it's this broad national
Yeah.
market, or are they going into the medical markets and saying, oh, because I find in the rec and medical markets you see much more claims and it seems to be a little bit looser there, and I wasn't sure why.
Yeah, I don't think it's looser. I think better to start with the claim rather than the ingredients. If you're making a claim about your product and associating your product with a disease, there's acne is a disease and cancer is a disease. They're going to come after people, and they do about more concerned about cancer and COVID than acne. So, they're pretty busy. They're not coming after a lot of acne companies. Having said that, you can walk here and companies are making claims that are just like, you can listen to XM radio, and I just drive and I'm like, my jaw drops about some of these erectile dysfunction. Well, you don't have to be on XM anymore. You can just be on TV. But, it just blows my mind what is being said. It's really a matter of, can you get away with it? So in other words, the FDA is not showing up here to go here because, they used to have to, right? But now everything's on the internet. They don't have to. They're just sitting in their cubicles doing this. If you go to a medical convention or you go to Natural Expo West or you go to the doctor's offices, just think realistic. How are they going to find you? How are they going to know about this? So really what they care most about are the most egregious defined medical claims that are being made, and they care about what's being communicated to the consumer. So if it's just in the medical context and I'm hearing, if I go to a dermatology, conference, or if there's a drug company that's selling to the doctors and they're making all these, how's the FDA even going to know about that? Right? So on the one hand, how are they even know about that? On the other hand, what the FDA cares about is making sure that products are safe and the consumers are not being misdirected to alternative remedies, which are totally unproven. And that's what these are. When you have a drug or a supplement that's out there, or any of these claims that are, take this instead, you won't get cancer. So now somebody's foregoing cancer treatment. Safe, protected, and the products are out there are not going to hurt people. On the other hand, the Federal Trade Commission isn't focused on the safety of the products per se. They're concerned about false advertising. Are you deceptively marketing primer from the FDA? They're saying, I'm here and you need to show me that you can substantiate your claims. It's a very different issue, but both agencies are very focused on it. The more serious the drug claims and the disease claims that you're making, the more heightened the risk. And the less, and even if you're making those disease or drug claims, but you're not broadcasting it, and it's just like if I were sitting here in this forum, it would be wrong for me to make those claims. But as a practical matter, unless the FDA is sitting here and watching me on my circuit of speaking, they're not going to come after me. So it's always wrong. It's always wrong to make those claims. Really, what is the risk? That's the analysis you want to go through, and it's going to be different in different contexts.
So fun fact, as a side note to that, GNC, which is a vitamin company, if you're not familiar with it, GNC has been in financial trouble for the last 18 months. GNC received a number of letters for GNC is now lobbying at the door for the approvals and the FDA authorizations for CBD because they see it as an opportunity to save the GNC brand. So there absolutely are other industries that are seeing the same kind of behaviors or targeting coming from government. I think that we don't hear about it or know about it because it's not our frame of reference. Same experience.
Can I add to that really quick? And I think what you're talking about is medical marijuana, right? So I don't know if you've seen, I haven't seen the FDA or FTC come after any medical marijuana companies currently, but it's because they really don't fit in the box for these two organizations. I think you will start to see those things happen, but what you really need to watch is the state regulation, right? I mean, I'm from Colorado. I'm way too familiar with California laws. And what you really need to watch there is because they will fine you if you are making those claims. Colorado has a robust labeling and claims policy. Packaging, but also you're going to a dispensary, right? So this isn't on Vitamin Cottage or Sprouts or Whole Foods shelves where anybody can pick them up. This is a place where you have to give your license and the things and the claims that are being made there are typically by a bud tender or something like that. It's not on your website typically. So that I think that's what you were kind of getting at, but I haven't seen anybody.
No, I'm glad you mentioned it and focused me a little bit more. The federal government,
Thinking, it's like you go into a dispensary, I'm in a medical state, I'm buying products, I have a medical card, but I'm also thinking about saying something like, this makes you feel happy. I go to the website and read reviews on products for the local dispensaries. I live in Illinois, but Missouri is medical, Illinois is rec, and you can read, people write reviews on the products. They talk about, I tried this, it made me feel great. Products and claims that they're making, and I didn't know if the FDA or FTC is looking at, like review.
Yes.
right.
Yes, absolutely. So they do, and they will nail you for those reviews. So I'll give the example.
No, that's on hemp. We're talking about medical marijuana.
Oh, sorry.
Yeah. The
Medical
federal-
marijuana is different.
The federal government, to be clear, let me put this, it is still illegal at the federal level. Okay? However, there is something called regulatory discretion. And basically what you have is the federal government saying it's still illegal at the federal level, which is why Biden just fired a bunch of people for having used marijuana. However, they have taken a hands-off approach and left it to the states. And so and that's why it's so important what was being said, the likelihood the FDA is going to come knocking on a dispensary door is pretty darn low. The likelihood that the local, state, city, don't forget, this goes down to the local, drug and health services, county. So you want to be sure that's who you need to be worrying about, not the federal government at this point. They are not taking an approach and going after dispensaries in states where it is medically, it's approved. So you have to be much, much more concerned with your local authorities, starting with the state down to your dog catcher. That's who you want to make sure. And to my knowledge, I'm not aware of them going after companies based upon what's being said in those dispensaries. They're more likely to get you on a licensing violation or some other manner in which you're operating. But if they get you on that, you can be sure that they're probably going to nail you on stuff you don't know about.
And more than likely, it's going to be your public health department that's going to come in and do that.
Now, keep in mind that you have CBD products in those dispensaries. So you're going to cross over some lines here because, again, treated differently than the dispensed products on the side of medical marijuana. And as a side note, to be clear, your reviews on your websites are investigated by the government, by the federal government. I bought a car 2 weeks ago. The sales agent told me that his wife had a stroke. She's my age, had a stroke 2 years ago, and that the doctors could not find a solution to that. So I handed him a 30-count bottle of my gummies, and I said, just try a couple of these a day. And within a couple of days, I got a review. Oh my God, my wife stopped having seizures, Jessica this, Jessica that. And I was, take it down, take it down, take it down, because the federal government doesn't like that. It doesn't matter whether or not it was true and factual for that particular endocannabinoid system and that body. What matters is that the claim was being made. And until we have definitive studies, it is so key to stay on top of that. Also, hard lesson learned, don't draw your studies to somebody else's study. So if it's on your website and you go, okay, but it's been studied and it was studied over here at the University of Nebraska, that's a no-no. Can't do that because you weren't part of the study. That was a lesson I learned this week. Yes, ma'am.
Actually, that's kind of what I wanted to ask about is, trying to educate the consumer. There are clinical studies out there that do provide, expanded information. And then how can you add that to your site without making a claim? So I just wanted to ask that since we own our real estate. And then the website's an extension of our label. So I just want to understand what you can and can't do with sharing research.
So there's layers to what you just said. So first of all, I do a lot, as I said, with cosmetic brands. And so, for example, they recognized that that was one of their problems, that they couldn't say about the product. So they thought that they could be clever, and instead they would have pages on their website that had discussions about the ingredients. And so they weren't saying my product does it, but my product has a lot of vitamin C. Next page. Vitamin C is known to get rid of wrinkles and do all these things, which, okay, are drug claims, okay? So this is, again, it's nuanced. Should you not have it anywhere on your web page? No, I think it's good and it's important to educate the consumer. It's a gradation. What else are you saying? How much are you tying it to the product? Now you've really made the inference that this product is going to achieve those results. So you have to be very careful about that. But let me say one other thing about studies, and that's the following. As you were saying, you can't rely on a university study or the like. It's not only that you weren't a part of that study. The issue that I see repeatedly with regard to substantiation is that I'll have a client come to me and they'll give me a report that substantiates the particular claim. But here's what I talk about, making sure that you can tie the report to your claim. Were the same people that were in that study the same target audience for your product? Are you using the same dosage of the ingredient that was studied in your product? So oftentimes I'll find that they're using X milligrams in the study and less than that is in the product. So you can't make that same claim, okay? Then you have to consider whether or not, even if the ingredient study shows such great things for CBD, are there other ingredients that are in my product that counteract that or reduce the efficacy that was studied? So it's very nuanced and you have to be very careful. Most companies do not want to do what we call finished product testing, and so they do rely upon want to make sure that nothing's counteracting it and the like. So it's not just so simple as saying, let me put out this information to the consumer and let them figure it out. That doesn't necessarily translate to your own product. And so if you're going to, again, have studies on your product, on your pages, you're inferring that your products are going to deliver the same. So you have to be very careful as you go about relying on them.
So understanding the nuance, I'm curious now, I'm thinking a different. What I'd like to do is educate the consumers on the inflammatory response to the body, and then studies around, that. And then not definitely link it to our product, but just, hey, you need to know what's going on in your body. And then here's the system that these drugs work in. Is that okay?
Okay, first of all,
not our product, but just
right. First of all, understand, to make an anti-inflammatory claim is a drug claim.
No, I just meant this is how it works.
I understand, but what your premise was at the beginning, you want to teach them about the endocannabinoid system in order to show that we have these anti-inflammatory benefits that derive from that, right? And what I'm saying to you, if you're going to make an anti-inflammatory claim, the FDA considers that and has been very clear that's a drug claim, okay? So again, it's really hard for me to, in the abstract, opine on this, but it's complicated. The risk, if you're not saying product X will do Y, it is an anti-inflammatory, but you're just on the website talking generally about it, that reduces the risk. But you are not still home free because you are still implying to the so it's very nuanced. As a practical matter, we have seen the FDA go after companies that are making drug claims, and in the letters that they're sending, they are pointing out the languages used to describe the ingredients, okay? So this is why I go to, if the worst thing you say about your product is it's anti-inflammatory, the chances that the FDA is gonna come after you, probably not so high. But if you're gonna talk about cancer and all these other things, and you talk about anti-inflammatory, yeah, they're just gonna throw everything into the kitchen bucket. But the likelihood that a company is going to get an FDA warning letter just because on their website they talk about CBD and proven anti-inflammatory effects, not too terribly likely. Talk about being able to cure cancer or talk about any serious disease, that's gonna shoot it up to the top of the list.
Sorry, just another, so if we're not just talking about CBD, but total health and wellness, and CBD is one part of it, like diet, blah, 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 that's less risk, I'm thinking, as well.
Yeah, I mean, I think that the more content you have and the less of it which is necessarily focused on a product that you're selling, the less likelihood again.
So I'll give you an example. My brand is cannabidiolife.com. And we were premised on education. My brand is owned by a 33-year-old kid who woke up one day and decided 5 years ago there wasn't enough information. Everybody was selling snake oil. So he started pulling studies from Israel, where it all began with Dr. Rafi and Hanush, and started pulling all of this data and information. And within about a year, he had an insane audience demanding the product because there was so much education on the website. Fast forward 3 years, I walked through the front door. They asked me to come on board full time. And the first thing I said was that whole thing has to be ripped out. Let me tell you about the fight with that kid. Because the entire brand had been premised on this education. But we had moved into the FDA now taking serious and paying serious attention to what was being said. It has been an uphill grind. At the end, we found a creative way to get it done. That education sits way the heck out there on a completely different URL. And it is floating way the heck out there under a completely different name. And you can find the links on the back end supplanted. Play it safe. We're not too far away from federal regulation. We know this to be true because Canada's pulling the trigger, Mexico's pulling the trigger. We got, I want to say there's like 20 more countries that have just pulled the trigger. Hang tough, because we're getting to the point where we really can blow this wide open. But again, you're making history, and it is an uphill grind. Any other questions? Okay, that's it from us. I am Jessica Arendt. Feel free to touch on and speak to any of our panelists. Thank you so much for being here and supporting CBD Expo.